Good morning, everybody. Thank you so much for taking the time to be here with us today. I'm excited to close out Green Worldwide's 2025 trade webinar with a comprehensive briefing. We'll be covering policies and enforcement actions that have helped shape global trade in 2025 and those that will continue into 2026. For all of the licensed customs brokers, certified customs specialists, and master customs specialists on the line, this webinar has been approved for credit, and I will be sharing the code towards the end of the webinar today. For those of you I have not met, my name is Kate Rayer. I am the Vice President of Regulatory Services at Green Worldwide. I've been in this industry for, over 2 decades now, almost 7 of them here at Green. I lead our Global Trade Solutions group. My team specializes in customs services, including foreign trade zones, duty drawback, tariff strategy and mitigation, and enterprise level customs brokerage. I'm actively involved, especially this year, in industry leadership, including with the National Association of Foreign Trade Zones and the World Trade Center Denver. In this session today, I'm going to be covering country-specific tariff and trade policy updates, reciprocal tariff adjustments, Section 232 investigations and updates, Section 301, what's going on with the IEEPA case, the Supreme Court developments. I'll also go into explaining general entry timelines and correction mechanisms, and I will share some practical advice for what importers could be considering doing now with the pending court case. Before we jump in, just some quick housekeeping notes. The chat has been disabled for this event. In the messages, you will see my contact information. So if you do have questions that I do not cover today, please feel free to email me directly. And again, my email address is in the chat. A quick disclaimer, information that is shared today is for informational purposes only. It should not be considered legal advice. Trade policy does move quickly, especially this year. New guidance from the administration or CBP could change what we cover today. So with that, I'll go ahead and get started, and we'll roll right into the country-specific updates. Okay, so what's going on with Canada and Mexico? So just last week, the administration threatened an additional 5% tariff on Mexico due to a water treaty issue. Additionally, the administration has threatened more tariffs on Canada. This was specifically targeting fertilizer and possibly other goods if broader trade or domestic goals are not met. We do have the USMCA 6-year joint review coming up soon. That's going to be happening in 2026. Regarding China, things have cooled off. So the IEEPA fentanyl related tariffs on certain China origin goods were reduced from 20% to 10% back in November. Section 301 tariff exclusions remain extended through 2026. Just an interesting note, so China's 2025 trade surplus exceeded $1 trillion in the first 11 months of this year, reflecting, they have a continued export growth despite the US tariffs. And just last week, it was announced that the administration is forming a coalition between Australia, Israel, Japan, Singapore, and South Korea. And this intends to address deficits in critical mineral access, idea being edging out China's massive investment in its critical minerals and tech sector. So the administration is actively looking for other countries to join this group as well. The UK, there has been some updates there. So the US announced its intent to apply 0% Section 232 tariffs on UK origin pharma and ingredients and medical technologies, pending implementation details there. The steel and aluminum tariffs out of the UK, there has been, a quota design that has been supposed to be coming, but that remains under development. We've seen no progress there. For Indonesia, there has been a framework trade agreement that is pending formalization. The negotiations are active, but there are still some unresolved issues that need to be taken care of. So because of this, the implementation scope, the tariff coverage, and the enforcement mechanisms are still under review. For Taiwan, these talks are still ongoing. There is no deal finalized yet with Taiwan, so the 20% reciprocal tariff rate does remain in effect until there's a final agreement executed. With India, there is still pretty high tariffs with India. There are active talks happening towards getting to a comprehensive bilateral trade agreement. The US delegation was just recently in India to try and close these gaps. But so far, the discussions with India do remain inconclusive. Brazil is another one that has high tariff exposure. Up to 50% does remain for certain Brazilian goods. That's 10% reciprocal, and then the 40% that's Brazil specific. Recently, though, there was some new exemptions announced back in November for select products, specifically in the ag space, that would specifically reduce those tariffs for those products. And with Vietnam, the 20% reciprocal tariff remains active on most Vietnam origin goods. Certain products are still pending outcomes there, so currently that eligibility list does remain unpublished. For South Korea, there have been some updates. So back in November, the US and South Korea released a joint fact sheet, which did confirm a new US-Korea strategic trade and investment deal. This is similar to the other deals that we have seen with the EU and Japan. This one, though, does have some retroactivity. So if you do have imports from South Korea, important to review and correct past entries to make sure those are correct. So the changes, they were done in two different dates of retroactivity. So going back to November 1st would be auto and auto parts, and then November 14th for other goods. Additionally, Section 232 duties were reduced for select Korean products as well. So the tariff arrangement with Korea is really looking the same to be as the EU, where if the existing normal general duty rate is greater than 15%, no additional tariff. If it's less, it's the 15% cap. And just announced yesterday as well, the Switzerland and Liechtenstein deal. This one also does have some retroactivity back to November. So just like if you have entries from South Korea, if you have entries from either Switzerland or Liechtenstein, those past entries are open for correction. So the implementation details for this one were just released yesterday. So if you do have entries from Switzerland or Liechtenstein, important to take a look through those and see if you do have the availability to correct and get some refunds for tariffs paid there. This one is also mirroring the EU, Japan, South Korea, where they're doing the 15% cap for reciprocal tariffs. With Argentina, Ecuador, El Salvador, and Guatemala, back in November as well, on November 13th, the US did announce framework trade agreements with all 4 countries. So these agreements, what they focus on are expanded access for US industrial and agricultural exports, reduced trade barriers, and duty and tariff adjustments. But for now, the baseline reciprocal tariff rate of 10% does remain in place. For Cambodia and Malaysia, both have reached new trade and investment frameworks with the US in the wave of the 2025 negotiations. The frameworks do keep the reciprocal tariffs at 19%, but it does provide 0% for specific products. For example, certain textile apparel from Cambodia, electronics and medical devices for Malaysia. And for Thailand, the trade framework agreement has been finalized there. The US maintains 19% tariff on Thai imports for now. The agreement does target future product-specific reductions or zero duty treatment. Thailand is committed to reducing market access barriers for US exports, including for specific sectors like industrial goods, agriculture, and automotive. And lastly, with Saudi Arabia, also in November, the US Treasury and Saudi Finance Ministry, they executed 2 formal frameworks. This is going to be the Financial and Economic Partnership and Capital Markets Collaboration. These agreements, what they focus on is cross-border investment facilitation, financial sector integration, and increased capital market transparency. Direct tariff changes have not been announced yet under these frameworks. So for now, no specific tariff changes. So just some quick updates on just the overall reciprocal tariff framework. So as we all know, back in August, the IEEPA reciprocal tariff structure went fully into effect. Countries listed in Annex 1 follow their assigned specific reciprocal rates, while countries not listed in the annex have a 10% tariff unless otherwise modified. So since implementation, though, we have seen several updates in the form of, the country-specific agreements that we just discussed, and with exemptions to these tariffs. So Annex 2 was revised back in September to both remove and add reciprocal tariff exclusions. And in October, 150 tariff numbers were pulled back into Section 232 from the timber, lumber, and related derivative products. And then in November, there were some additional exemptions granted specifically for the agriculture industry. So importers should assume that reciprocal tariffs will continue to apply and stack unless there is, a specific exemption or there is an alternative agreement formally issued. So back a couple months ago, you may have seen that there was a public announcement regarding a proposed 100% tariff on patented and branded pharma products with a proposed effective date of October 1st. So the administration publicly stated that patented and brand name pharmaceutical products would be subject to 100% tariff unless that manufacturer was actively building or opening a U.S. production facility. So since then, and as of this time, there are no Federal Register publications for this. There is no CBP guidance, no defined HTS scope. So still a lot of questions on what's really going to be included in here or excluded. So industry discussions are underway with several major pharma manufacturers, including Pfizer and AstraZeneca. They have reportedly entered negotiations. Eli Lilly and Novo Nordisk have received formal invitations to negotiate as well. Specific country tariff arrangements like the EU, South Korea, Switzerland, and Japan, they have received secured limited pharmaceutical carve-outs. And it also was announced that UK medicines, active ingredients, and medical technologies will be exempt from tariffs, including Section 232. So again, nothing formal on this one yet, but it is still on the radar, so something to watch. Okay, I also want to discuss the Section 232 investigations. So Section 232, what it is, these are related to national security. So these sectoral investigations have become a favored tool of the administration. They typically take between 9 and 12 months to complete the whole process. So outside of copper, steel, aluminum, auto, we have seen some of these investigations move into the tariff phase. So during the Section 232 investigation, what's happening is the Department of Commerce's Bureau of Industry and Security, so BIS, they gather data, they solicit public comments, they assess supply chain risks, and if that investigation concludes that the imports of these specific commodities, hard to get that out, if they threaten national security, the president can respond with tariffs or other restrictions. These commodities that are currently being investigated and or have new tariffs are the timber, lumber, and derivatives. The tariffs for these have been in place since October. There are some increases to these tariffs coming in next year. Trucks, medium and heavy duty, and parts. These tariffs were announced and have been effective since November. Pharma and pharmaceutical ingredients, which we just talked about. This one, there were the tariffs announced, but we are still pending implementation details. Other commodities on the horizon include semiconductors and semiconductor manufacturing equipment. So this investigation was initiated back in April. So we should be seeing some sort of decision on this one, based on the timeline as soon as late December of this year, but it might occur as in early 2026, given where we are in the year. Other commodities include processed critical minerals and derivative products. This again was also initiated in April. So again, based on the timeline, this should be early 2026. Commercial aircraft and jet engines, this one was a little bit later, so this was initiated in May. This points to also early 2026 for a possible report and subsequent presidential decision, assuming the investigation runs near the statutory maximum time frame. Other commodities include polysilicon and its derivatives. This one was initiated in July. Unmanned aircraft systems and parts, this one was also initiated in July. Additionally, there have been some new 232 investigations that were announced, including personal protective equipment, medical devices and supplies, robotics and industrial machinery, wind turbines, and there also is a potential for energy storage and battery inputs to be targeted for 232. So for each of these where tariffs haven't been announced, once again, once Commerce completes its investigation, it reports its findings to the president, and if the report concludes that imports do pose a threat to national security, tariffs or other measures may follow. So if you do have commodities that may be impacted here, it's important to monitor these timelines, consider submitting comments as part of the investigation process, and do prepare for potential outcomes, including possible tariffs. All right, so covering the Section 232 steel and aluminum. So earlier this year, back in mid-August, Commerce announced there were going to be over 400 additional tariff numbers included in Section 232 for steel and aluminum. And this significantly widened the list of products that were subject to 232. Many products that historically were not a part of Section 232 were now included, which did increase, compliance burden, tariff exposure. This one happened in a very quick implementation. I think these were announced on Friday, 5 p.m. and went into effect the following Monday. So just to keep everyone updated with the process here. So between September 15th and September 29th, BIS opened a short inclusion window, so not an exclusion, an inclusion window. What this did is it allowed parties to request that additional products be formally included in the Section 232 tariff scope. That window, it's now closed. So during that window, there were a total of 95 inclusion petitions that were filed, and this covered hundreds of different tariff classifications. And under the governing presidential proclamations and BIS regulations, Commerce is required to issue decisions on these within 60 days of receipt. Well, that window has already passed. As of today, Commerce has not yet published those decisions. I have not seen any formal explanation as to why the delay. So what does that mean is, we may still see additional products become subject to Section 232 steel and aluminum tariffs for this inclusion round, which could be announced soon. However, at this time, we do not know exactly when. So looking ahead, the next formal inclusion window is expected to open again in January. So based on the timelines, the publication of decisions for this would likely be in March or April, assuming that Commerce follows the typical cycle. So additionally, outside of Section 232 for steel and aluminum, a similar process will soon be initiated for auto parts. So in January, a similar inclusion window will open. This is a 2-week window for new products to be submitted for possible inclusion. They will be submitted before January 14th, after which the agency will post the requests for comment. That will be a 60-day process, and then this was originally supposed to happen back in October, but it actually didn't because of the government shutdown. So Commerce has said that this process for inclusions will be a 4-time per year event. So they will be happening in January, April, July, and October. So the bottom line with the 232 tariffs is that the scopes of these will likely continue to evolve and expand. So it's something to very much pay attention to. As we experienced with the August rollout, these things tend to happen very quickly once they're announced. Okay, so one of the most common and most misunderstood questions that we've been seeing is about Section 232 derivative products, and how to determine the value of the steel or aluminum content when the product needs to have that value split out. So it's important to level set that official binding guidance from CBP headquarters does remain very limited on this topic. So on the screen here is from the Section 232 FAQ on CBP's website, which hasn't been updated for some time now. So the way this has been worded has led to different interpretations. So the language states that the value of the steel and aluminum content is the total price paid or payable for that content, which is the total payment, direct or indirect, and exclusive of any costs, charges, or expenses incurred for transportation, insurance, and related services incident to international shipment of the merchandise from the country of exportation to the country of importation, made to be made for the steel aluminum content by the buyer to and for the benefit of the seller of the steel aluminum content. And normally this would be based on the invoice paid by the buyer of the steel and aluminum content to, or for the benefit of the seller of the steel and aluminum content. So one interpretation in the trade community has been that this means that the value is the price actually paid or payable for the steel or aluminum content itself, or the raw material cost of that steel or aluminum, not the value of the steel or aluminum in the finished article as part of the entered value to customs. So this has been the source of much confusion and a lot of questions just based on different interpretations of this language. Okay, so what I do want to talk about is some additional information or guidance that has been released. So recently, CBP's Base Metal Center of Excellence has been circulating guidance. It is not formally published. We have been also seeing different CF 28 and 29 requests related to steel and aluminum valuation. It isn't clear that this guidance from the Base Metal Center of Excellence represents final or even official policy position of CBP headquarters. It did not come out via an official channel, and it is not on CBP letterhead. So in this informal guidance, what the C indicates is that the value of the steel or aluminum content is the amount the importer paid for the steel or aluminum content as incorporated into the finished article. This is a different interpretation than many had when reading the CBP FAQ. So in practical terms, this guidance states that you start with the entered value of the finished product, and then you subtract only the value of the non-steel and non-aluminum components for subject products. But this is only if the product is outside of Chapter 72. The key point or difference in this specific guidance is that it is not the raw material cost of the steel or aluminum. They are indicating this is the steel or aluminum portion of the entered value. So one example that was in a CF 29 was a steel bolt with a nylon washer and a nylon nut. In that case, you may separate out the value of the nylon components as non-steel. Everything else remains part of the value. Another example provided in the unofficial guidance from the C is a window. The example poses some questions that help explain this position. So what did the importer pay for the finished windows? If the windows have non-steel components like the glass, what was the cost of the glass to the importer? If you minus the cost of the non-steel parts like the glass from the total window cost to the importer, then that equals the Section 232 steel content value. So if the importer paid $100 for the window, $20 is the value of the glass, and the entered value is $100, the steel content is $80 and the non-steel content is $20. Keep in mind, at this time, there is no official guidance from HQ allowing importers to back out costs such as fabrication, machining, labor, finishing, and coating. If a cost is a part of the entered value and not otherwise deductible under customs valuation law, it stays in. If the importer cannot reliably determine the steel or aluminum content value and be able to prove it, The default guidance is to report the full entered value for Section 232 purposes. For this, documentation and consistency are key. So CBP expects that importers maintain clear records showing how any steel or aluminum value was calculated. If challenged, the burden of proof is on the importer to support the methodology. The documentation should include sufficient information to support the importer's claimed steel or aluminum content value. So the bottom line here is that, until CBP HQ issues formal binding guidance, this area does remain unclear. So strategy and valuation of 232 impacted products, it should be carefully reviewed and considered. Okay, so getting into some important Section 301 developments in terms of exclusion relief or new and expanded investigations. So let's start with the exclusions. On November 29th, the USTR announced that many existing product-specific exclusions under Section 301 China tariffs have been extended through the end of next year or November of 26. This means that for the covered HTS codes, additional Section 301 duties remain suspended through that date unless the USTR revises the list again. So companies should confirm that their products do match the exclusion language exactly, as they are very specific. And then in November, the USTR announced a 1-year suspension of actions under the 301 investigations into China's maritime, logistics, and shipbuilding sectors. So this suspension began on November 10th, and during this period, there will be no new tariffs, no new port fees, and other immediate enforcement actions under this 301 case. We also continue to see Section 301 activity expand geographically. So a Section 301 investigation into Brazil is currently underway. Some tariffs were already imposed earlier in 2025 under an emergency order, but portions of that exposure have been rolled back, like we talked about the new agricultural exemptions, while this broader investigation continues. What this does is, it does reflect a clear expansion of Section 301 beyond Asia and into the Western Hemisphere. In October, the USTR initiated a new 301 investigation into China's implementation of the Phase 1 agreement back from the first Trump administration. So the focus here is whether China fully met its commitments, whether any non-implementation creates a burden on US commerce, and what, if any, additional actions may be warranted. So this investigation creates potential risk for new or reimposed trade actions. And also turning to Nicaragua, so USTR announced new Section 301 tariffs effective January 1st of 26. This applies to goods of Nicaragua that do not qualify under the CAFTA agreement. The tariff structure is phased, so 2026 will be 0%, 2027 10%, and 2028 15%. And importantly, goods that do qualify under CAFTA remain exempt to these additional Section 301 duties, which makes origin qualification documentation critical for companies that are sourcing from Nicaragua. So overall, the takeaway here is that Section 301 does remain a very active tool. There's a mix of relief, suspensions, new investigations, so important to monitor exclusions, origin, eligibility, investigation outcomes closely. Okay. All right, let's talk about what's going on with IEEPA. So this is a very hot topic that everyone is following. It's been in the news cycle regularly. So first, I want to talk about the background. So back in August, the Federal Circuit ruled that the IEEPA does not authorize the imposition of tariffs. This ruling effectively undercuts the legal foundation of certain presidential tariff actions that relied on the IEEPA authority. However, this decision was stayed until October, which means at that time and still today, the tariffs remain in force. In September, the Supreme Court agreed to review the case, and the oral arguments for this occurred back in the beginning of November, on November 5th. So depending on the outcome, the Supreme Court ruling will significantly reshape executive authority over trade remedies and tariff setting power of the executive branch. If the Supreme Court ultimately invalidates the tariff imposed under IEEPA, the importers may be eligible to seek refunds. And I know that has been a big question of how and when and what is the process for this. So we'll talk more about that here in a little bit. But really, this could be one of the most impactful trade cases in recent history. It directly determines the extent of the president's unilateral power over tariffs. Currently, as we all know, the outcome is uncertain. At this point, a decision in 2026 is expected, with the latest information pointing towards early January. So, hopefully right after the holidays, we know which way this is going to go. So another important decision was issued just recently. So back on December 15th, so this was regarding the pending IEEPA litigation. So the key takeaway of this decision by the court was that liquidation of an entry does not prevent the court from later ordering refunds if the IEEPA tariffs are ultimately found unlawful by the Supreme Court. So in this decision, the court relied heavily on the government's own representation. So the government has taken what the court called an unequivocal position that liquidation will not affect the availability of refunds after a final decision. Because of that, the court found that the government would be barred from later arguing that liquidation prevents refunds. The court also reaffirmed that it has the explicit authority under 1581I to order reliquidation and refunds in cases involving constitutional challenges. So as a result, the court concluded that the subject importers are not facing harm simply because entries are liquidating. And on that basis, it denied the request for a preliminary injunction to stop liquidation. This denial, it's really important to understand that it does not mean that refunds are unavailable. It means that the court does not believe that liquidation of an entry by itself eliminates the possibility of recovery if the tariffs are later struck down. So there are two important things to note here is that right now this decision only applies to the pending court cases at this time. It does not automatically extend to all importers or all entries. And second, the court made it clear that there is a possibility that IEEPA tariffs will not be recovered by filing administrative protests under 1514. So where does that leave us? The availability and process for refunds, it remains unsettled. This includes, first, how the Supreme Court is going to rule, and second, what is going to be the process for how to get refunds if they are ordered. Currently, right now, there is no statutory process for this. So this is, again, an unsettled matter. Okay. So there were a lot of terms that I just went over there that some may not be familiar with. And I've been getting a lot of questions related to liquidation. How does the entry cycle work? How do post-summary corrections work? How do protests work? When can you file a protest? So I do want to cover this today. So just starting from the beginning, I want to start with the entry date, which is also called the time of entry. This is the date when the entry summary is filed in proper form with duties estimated and attached. So importantly, it can never be earlier than the actual import date. So on the CBP Form 7501, you will find this reflected in box 7. This date is also going to be available within your broker's entry data or within ACE. So what is liquidation? Liquidation, what it is the final computation of duties owed on an entry. Think of it as CBP's final stamp of approval on the duty amount for that entry. So how it works in practice is liquidations are processed weekly. So entry summaries are liquidated every Friday. And once ACE liquidates an entry, the liquidation date is automatically set to the next Friday. And if entries are processed before Wednesday at 11:59 p.m. Eastern Time, they appear in that same week's Friday posting. If they process later, they roll to the following Friday. Formal liquidation notices are posted on CBP's website, and they do remain visible for at least 15 months. So actually on CBP's website, towards the bottom of their homepage, there is a link where you can go in and check the liquidation status of an entry by the entry number. So if you do just have an entry you want to look up, you can go in there and plug in your entry number and you can look it up directly on CBP's website as well. So why does liquidation matter? The entry date and liquidation timeline affect both post-summary correction processes and protest deadlines for correcting the entry. So diving more into how both of these mechanisms work. So a post-summary correction, also known as a PSC, what it is it's essentially a replacement of an entry summary before liquidation. So a PSC can be used to correct entries for most issues, and the key requirements here is that the entry must be in accepted status and in CBP's control and not under CBP review. Duties must be already paid, and the entry summary and the entry must not be already liquidated. So PSCs, they can be submitted within 300 days from the entry date, but no later than 15 days before liquidation, whichever comes first. So PSCs, they're more of a proactive correction tool, so they allow trade to fix errors before CBP finalizes the entry. And protests are a formal legal mechanism for challenging CBP's decisions. Common reasons for filing a protest would include clerical errors, mistakes of fact, or inadvertence in CBP's decisions. So brokers and importers have 180 days from the notice of liquidation to file a protest. And once filed, CBP reviews the protest and all of the related entry data and documentation that accompanies it. And legally then CBP has 2 years from the date of filing to issue its decision. And again, the process or mechanism for potential IEEPA refunds is unknown. Okay, so we don't know yet if they're going to say, hey, you need to file a PSC, hey, you need to file a protest. As of right now, we do not know. So together, though, these tools, if you do have entries that need correction, for maybe you need to go back and correct your South Korea entries or your Switzerland entries, these are going to be your mechanisms to do so. But again, we do not know if this is the mechanism for any potential refunds for IEEPA at this time. And I do want to just show a quick example of the entry filing timeline. So this is just a sample entry date to illustrate how it works. So let's say your entry date is January 10th of 2025. In that case, your summary date would be January 27th. This would be when the entry summary is transmitted and accepted, and this date is what sets the clock for many downstream deadlines. So the PSC deadline in this case would be 300 days from the entry date, but no later than 15 days before liquidation. So in this example, your estimated last date to file your PSC would be November 6th. And then your estimated liquidation date would be November 21st. Okay, so again, CBP typically liquidates entries about 314 days after entry. And in this case, this would be right around November 21st, just depending on which day of the week that was. Once the deadline passes and an entry liquidates, PSCs are no longer an option. So then you would have to move towards the protest process. And again, in this situation, you would have 180 days to file the protest. So in this example, the last day to file the protest would be approximately May 20th, 2026. So the key takeaways here is that PSCs are pre-liquidation tools and protests are post-liquidation remedies. So just to hopefully help you understand how much time you're working with when correcting entries. Okay. So now that we've gone over all of that, I've been getting a lot of questions of, what should I be doing right now? What is realistic? One, follow the updates. Obviously, everyone's really in tune with this case, but keep following it. Obviously, the decision expected in early January would be good, so we would all have a game plan for what needs to happen, but continue to follow it closely. There is a possibility, and a big possibility underlined there, that litigation will be needed for refunds. If the tariffs are invalidated, we would think that there would be a mechanism that would be established short of a court filing, as the CIT does not want, hundreds of thousands of complaints filed for refunds. Keep in mind, there are over 300,000 importers that have been impacted by IEEPA tariffs. There have been millions of entries that have been subject to IEEPA tariffs. So again, I think there's going to be some sort of process for this short of a court filing, but again, this is uncharted territory, so we again don't know yet. If you would like to file a court case now, this is absolutely something you can do. You can also choose to wait and see what the decision is, which again, we do expect will be announced in early 2026. So today, CBP cannot issue refunds based on the IEEPA tariff being legal or not. The Supreme Court has not yet issued its decision, meaning this is not currently a protestable issue. That means that protests filed solely on the basis that the IEEPA tariffs are unlawful is not something that CBP can currently act on. Second, entries will continue to liquidate. Filing a case in court will not stop that act. This will not stop liquidation unless a preliminary injunction is granted, which again, this was just denied in court. So what you can do now is, analyze your past entries that were subject to IEEPA tariffs. While the DOJ has stated that it will not challenge the reliquidation ordered by court, it is essential to really understand your overall IEEPA exposure. And this is where your data becomes critical. So make sure your ACE portal is active, make sure you pull data from ACE, but also from your customs brokers and your internal systems. ACE does provide entry summary data, entry line detail, summary corrections, liquidation status, duty payments, refund status, CF28, CF29 data. So there's a ton of data available to you as an importer in ACE. So leveraging that to really understand your exposure aligned with your customs broker data and your internal data will really help you understand what your overall exposure is. So looking at ACE specifically, there are reports that can be used that would be helpful. So your entry summary reports would include your ES001, ES002, and ES003. And your liquidation reports in ACE would be the ES701 and ES702. All of these together will help you, track what's going on with your entries and really understand how your exposure is lining up. So also with ACE, if it does eventually become, that there are refunds available, there is a process and the refunds would need to come via ACH. It's very important that you do set up ACH refund within your ACE portal. So that is a tab within your portal that you can go in and you can put your bank account information in. So that way, if and when you get refunds for IEEPA or for other entry corrections or whatever happens, having that set up will enable you to get your refunds via ACH, which is obviously a much cleaner and more efficient process. Finally, this is a critical piece. So ensure your records are complete and compliant. So if there is a process where entries do need to be corrected via a mechanism, we would like to think that the process will be similar in nature to a protest if it's not a protest, where you'll have to provide entry details, entry data. CBP will always reserve the right to request whatever documents they need. So making sure your records are complete and compliant is going to be very important. Also important to maintain proof of payment of the tariffs. And again, I know I'm being a little repetitive here, but I just want to be clear that we do not know yet what the mechanism for refunds will be. We don't know if this is going to be post-summary corrections or protests, or if there was going to be a special mechanism set up specifically for this. We also still do not know if this is even going to happen. So really making sure that you are keeping an eye on your data, understanding your exposure, have clean data, ensure your entry compliance, have your records, follow what's going on, and then be ready to act is really a solid strategy at this time. And last up, I do want to talk about, based on what's going on with IEEPA, there are other tools that can be used for tariff implementation. And the ones that I want to go over are the ones that Congress have delegated to the president to impose or adjust tariffs. So at this point in time, I think, most everybody's familiar with Section 232. These are related to threats to national security. These are sector or product specific. These are done under the commerce. And for these tariffs, there is no duration limit and there is no tariff rate limit that can be imposed under Section 232. Section 301, again, this was widely used in the first Trump administration. So this is main tool for China during that time. This one deals with unfair trade practices. This has been for China, Nicaragua, and Brazil. This one is done under the USTR. It does have a duration limit of 4 years, but it does have unlimited extensions. And under 301, there is no tariff rate limit. In IEEPA, like we just went through here, these tariffs are related to national emergencies. So this one is not under any agency. So there's also no tariff limit, and there's also no duration for these. And the ones I want to talk about more that are less known is Section 201, Section 122, and Section 338. So if, IEEPA does get struck down, the reason I'm explaining this is because there are other tools in the toolbox that the administration can use to impose tariffs. So Section 201, what it's designed to do is to protect domestic industries. Okay, so it allows temporary tariffs or quotas to protect a specific domestic industry from a surge in imports. So it's a safeguard action. It's been used for solar, washing machines as recent examples. These measures, they are time limited, and what they're meant to do is give US producers breathing room to adjust. So these are done under ITC. They can be used for 4 years with a 4-year extension, and they do have a tariff rate max of 50% with a phase down being required. In Section 122, what this does is it addresses international payment imbalances. It was written originally to address serious balance of payment problems. For example, this could be a rapid loss of US foreign exchange reserves. So although it could technically be used to impose temporary tariffs, it has not been used in the past to impose tariffs. And that does reflect, the narrow economic scenario that this was designed to address. Section 122 is not under any agency. It can be used for 150 days, and it does have a tariff rate maximum of 15%. And lastly, Section 338, what this one is about is discrimination against US commerce. So it empowers the administration to respond when a foreign country or nationals engage in discriminatory or unreasonable practices that burden US commerce. So like Section 122, it has also not been used to impose tariffs, but it does remain, a dormant tool in the legal toolkit. And the president may use it to increase duties, impose new duties or restrictions. Section 338 also has no agency. It has no limit on the duration of tariffs and has a maximum tariff rate of 15%. So, taken together, these really give the administration a variety of different levers. Some, like we know, have been frequently used. Others are really symbolic. They create flexibility in US trade policy without waiting for new legislation. So again, if IEEPA is turned, we may start to see these become more commonplace, and we may see them be used to implement a new or different tariffs, specifically under 201, 122, and 338. All right, and now it's time for a little bit of fun. So I think everyone enjoys seeing their Spotify Wrapped if you use Spotify. So we put together just a fun recap of what has happened this year and just how challenging of a year it has been for all of us that have been impacted by trade this year. So just for some figures. So in 2025, the statistics through the end of October, there was $216.7 billion collected in duties, taxes, and fees. This amount does exceed the GDP of 100 countries worldwide, so staggering amount of collection there. 232 tariffs, this figure is again through the end of October. This is $38.24 billion. And just for a fun comparison, for this amount of money, you could probably build, 3 to 4 large theme parks. You could buy, luxury resorts in the Caribbean. It's again, a staggering amount of money that has been collected in 232. Total IEEPA tariffs, these figures are actually through December. There's $129 billion that have been collected under IEEPA. And for this amount, you could buy 2 to 4 different Fortune 500 companies simultaneously. So a lot of money that has been collected under IEEPA. So 300,000 plus importers have been impacted by IEEPA. And for a comparison there, that's bigger than the population of some cities, like including St. Louis, Pittsburgh, Orlando, and Cincinnati. So ton of importers have been impacted by IEEPA, which is why everyone's kind of waiting to see what do we need to do, what's going to happen, but wanted to share that figure with you so you can understand just how big that scope is. There have been 34 million entries impacted by IEEPA through December. So like we were mentioning earlier, if the process is that there's going to be, a one-by-one process of post-summary correction or a protest process where you can include multiple entries on it, the amount of corrections that need to happen if tariffs are invalidated is enormous. So 34 million entries have been impacted by IEEPA. That does come out to roughly 3 million a month or about 93,000 a day. So again, ton of entries impacted here. There's also 19.2 entries impacted that, 19.2 million, excuse me, that are unliquidated or about 1.7 million per month. And 32 different updates to the HTS book we saw this year. So looking historically, so previously 2022 to 2024, there was a total of 33 updates. So 2024 had 10, 2023 had 11, and 2022 had 12. And so far in 2025, we are at 32 updates to the tariff book. And last up, there have been 24 different trade and tariff-related executive actions. So if you feel like it's been, tough to keep up with, these numbers really do illustrate, the why. 24 different changes. This is different fact sheets. This is different executive orders that we've seen come out related to trade. So with that, as we wrap up, I'll just say this, 2025 has been one of the most complex and, unpredictable years we've seen in trade. Between shifting tariff authorities, court challenges, rapid policy changes, simply keeping up has been a real challenge. So if there is one key takeaway, it's that compliance isn't just about knowing the rules. It's about understanding how they're evolving, documenting your decisions, staying flexible and agile as the landscape does continue to shift. So thank you for spending part of your very busy year with us today. We know how valuable your time is, and we appreciate the trust that you place in us to help make sense of all of the chaos. So on behalf of the entire team, we wish you a safe, restful, and well-earned holiday season. We do look forward to continuing the conversation with you in the year ahead. So the code for obtaining your credit for this webinar, if you're looking to get your CCS, MCS, or LCB credit, is on the screen. This code is what you'll need to enter into NEI on NCBFAA's website. So again, if you did have a question, please feel free to email us, and I will be getting back to those who have questions. We will also be sharing this presentation for the attendees, and that will be sent out early next week. And again, thank you for spending the time to be here with us today. I really appreciate it, and happy holidays.